The court is going on the record in the matter of William Branson versus Heather Collins, 2402269, and appearance for Mr. Branson.
Good morning, Your Honor. Amy P. 0461 on behalf of Mr. Branson.
Okay, I'm sorry, what would you say your name was, counsel?
Amy Ducre.
Ducre, okay, I didn't hear the last name, I just heard Amy, okay. All right, and
Good morning,
I did receive your appearance as co-counsel, and I'm sorry, counsel, your appearance.
Okay. Good morning, Judge. I'll leave that up here on behalf, also on behalf of Mr. Branson. Your Honor, I asked Ms. Ducre to come in because before she became a lawyer, she was a elementary school teacher and has got a lot of experience with.
Okay, hold on,
handling
hold
this
on,
issue.
we'll get to that in just a moment, right now I'm just putting everything on the record.
Yes.
All right, and Mr. Branson,
Good morning, Your Honor.
your name for the record, please.
William Branson.
Okay, good morning, okay, and counsel?
Good morning, Your Honor. This is Megan Dalgala. I appear on behalf of the defendant, Heather Collins, today.
Good morning, and your name, please, ma'am, for the record.
Collins.
Okay, thank you. Okay, so today is the adjourned date for the parties to return. The issues that are, there's a couple things that we are hoping to resolve today. One is the escrowed monies. The other are utilities. And then there are some allegations as well regarding mail as well. The defendant had filed a motion to dismiss. Ms. Collins did improper prior to Ms. Declala submitting her appearance. And let's handle the issue of the, we're also going to address the issue of the order regarding the inspection. I've reviewed the order. I'm not going to sign it as written because this court did not order paragraph 2 that was added into the order. This court, obviously if there's a violation of an order, there's recourse. But I didn't state in there regarding any interference or third party, so I'm not signing that order as submitted. So that would have to be removed before the court signs it.
Your Honor, can we do that now and resubmit it to you?
What?
We'll do it now and resubmit it to you. As she's listening, she's the one that's going to be.
Okay, that's fine. I'm just saying that, that's probably can be submitted. I'm just not signing it as currently submitted. The court is also going to address the issue of the, I don't want to call it an inspection, but I don't know what I want to call it. Mr. Branson's ability to look at the property as far as what maybe needed to be done or whatnot. So that was on the 10th, so we'll address that as well. Okay, so there is an allegation that Mr. Branson cannot proceed because he does not have a valid CFO. Ms. Collins, in her motion, references a specific paragraph that would not allow Mr. Branson to continue. Item 7 on the complaint states the plaintiff declares that this residential property was kept fit for the use intended, has been kept in reasonable repair during the term of the lease or license, and is in compliance with the applicable state and local health and safety laws. Okay. Any defects in the statement must be explained below. And then it says the disrepair or violation was caused by the tenant's willful or irresponsible conduct or lack of control. So counsel, I understand that your client filed this, but you also did indicate at the last hearing on Tuesday that you were relying upon the motion. And so what part of that would require this court to dismiss this action.
Your Honor, this action must be dismissed, under MCL 125.530. That is the Michigan law that requires a certificate of compliance to be held by a landlord. Under paragraph 5, it states that an action may be maintained where there is not payment into an escrow account. So
I'm sorry, what was that? An action what?
may be maintained, an action to recover possession of the premises may be maintained where there is not payment into an escrow account. My client has been paying into the court's escrow. I have the register of actions here.
No, I understand. Yes, this court signed an order of escrow.
Correct, and she is in complete compliance with that. On January 21st, she paid $4,000 into the escrow account as ordered. On January 31st, she paid her monthly rental amount in the amount of $1,500. Of course.
Sorry, just one moment.
Sure.
So you're relying on MCL 125.530, paragraph 3, which you said paragraph 5.
I did say paragraph 5. I'm actually relying on the entire, all the provisions of 125.530.
Okay, so just one moment, please.
Yeah.
So counsel, you have 125.530 pulled up?
Yes, Your Honor.
Okay. Okay, so I believe that 125.530 would speak specifically to the issue as to where the monies go from the escrow account.
Your Honor, if I may.
Just one moment, please.
Sure.
Right now, I'm addressing the motion to dismiss portion of it, not the portion that we're going to address regarding the payment of the escrow account. So as to the motion to dismiss, Ms. DeClala, what in paragraph 7 would support the request to dismiss this action?
Okay. So I'm referencing 125.530, generally. This was brought up in the defensive responsive pleading and it was relied on quite heavily. It's actually stating that the property can't be legally rented out when it doesn't have a certificate of compliance. You know, that's pretty obvious to us. The issue here is whether an action in eviction can be maintained summary proceedings in local district court where there is not a valid certificate of compliance. There's certainly not a valid certificate of compliance in this case. We're all aware of that. There's an inspection scheduled with the city in order to correct for that. In particular, I'd like to draw your attention to the court rule for these proceedings. In particular, I'm referencing MCR 4.201 B3C.
Okay, let me pull that up.
Again, that's MCR 4.201 B3C. I'll go ahead and read it.
Hold on, counsel, just one moment.
Sure.
Complaint specific requirements, 3C. If the tenancy is of residential premises, the complaint must allege that the lessor or licensor has performed his or her covenants to keep the premises fit for the use intended in reasonable repair during the term of the lease or license and in compliance with applicable state and local health and safety laws, except when the disrepair or violation has been caused by the tenant's willful or irresponsible conduct or lack of conduct, or the parties to the lease or license have modified those obligations as provided for by statute. Plaintiff must explain any defects in this allegation, for example, local government's failure to inspect despite a request to do so. The relevant scale form must provide space for this explanation. The court may not refuse a filing based on anything in this sub-rule. Okay?
Okay.
So you're relying on the part stating that the plaintiff is not in compliance with applicable state and local health and safety laws?
Correct. And
Okay, so what local health and safety laws are not in compliance?
okay. That would be the City of Wyandott's Ordinance 181.020. No,
Sorry, 181,
0.020.
okay.
No person shall lease, rent, or cause to be occupied a rental dwelling or rental unit unless there's a valid certificate of compliance.
Okay, so does that fall under state and local health and safety law?
Yes, it does.
Okay, how does that fall under there? Because that seems to me to be an ordinance that the city can then enforce against Mr. Branson.
Absolutely, Your Honor. But you know, that's exactly to my point. It's something that the city can enforce, and this is meant to protect the safety of its citizens who are renting out residential units. So it's in direct conflict with the court rule that requires when you file a complaint in these matters for the landlord to represent that the residential property is being kept fit for the intended use.
Okay, so what's in direct conflict, counsel?
Okay, what's in direct conflict is that the certificate of compliance is required to assure the health and safety of the citizen living in the unit. So in order to file a complaint and represent that it was kept fit for residential use, not only is it required under local law for the city of Wyandotte under section 181.02, but also under the court rule for filing these actions, the complaint must allege that the premises is kept fit for the intended use and it's in reasonable repair. So as you mentioned, then it goes on to state in compliance with applicable state and local health and safety laws. Certainly, 181.020 is a local ordinance that's protecting the safety and health of its citizens. That is a local ordinance that's meant to do that.
Okay, and your response, counsel?
Your Honor, my response is severalfold. First of all, the applicable MCR 4.201 sub B, sub 3, sub C clearly states in its express language that that this matter cannot be dismissed for a defect of this section. It says that, it's the last line in here. The court shall not refuse this pleading because this is not complied with. So even if there is a defect in the way that he pled this pleading, that doesn't mean that it should be denied.
Okay, it reads, a court may not refuse a filing based on anything in the sub rule. So the court has to accept the filing. Okay, so the fact the court has to accept the filing doesn't mean that it cannot be used as a basis to dismiss the matter, but I just wanted to clarify that.
Yes.
Okay.
So that defect is not a fatal defect on as sister counsel claims on the face of the pleadings. That's my argument, Your Honor. Second of all,
I'm sorry. So the defect that your client does not have a certificate of compliance or certificate of occupancy, whichever the title is. I think that it was changed at some point. And so you're stating that that is not a violation of the third part being in compliance with the applicable state and local laws?
It's not a local health and safety law, Your Honor.
Okay.
This is a municipal code under the building code. And if you read section 181.001, where it talks about the certificate of compliance and the purpose of it, a certificate of compliance is issued by the Department of Engineering and Building, which certifies compliance with provisions of codes and ordinances of the city for all rental and dwelling units. There's no mention anywhere in the statute that this should be applied as a health and safety standard. And without actual case law or some citation or some legislative and quasi-legislative intent of the body who enacted this, it doesn't fall within the health and safety laws of this city or the state of Michigan. Moreover, there is a direct statute on point, Your Honor. And that direct statute is the statute that Ms. Aflalo was talking about first. And if we go provision by provision through this statute, Your Honor, you can see that their argument is completely erroneous with the plain language of the statute. And we're talking about section 1.25.530. And if you talk about subsection 5, for instance, it is clear that it says when the certificate of compliance has been suspended or has not been issued and the rentals thereafter withheld are not paid into an escrow account, meaning Ms. Aflalo and defendant are looking at the wrong time period. The defendant did not put monies into an escrow account until she got involved with this court proceeding. She had provided zero evidence or zero proof that there was any escrow account. Moreover, if you continue to read that provision, Your Honor, it says that the escrow account must be managed by the authority with the department with the authority to oversee compliance with the certificate of occupancy, meaning that the defendant would have had to place, at the time she withheld those rents, at the time she decided, I'm gonna withhold the rents because you don't have a certificate of compliance, she would have had to place those monies in escrow with the building department of the city of Wyandotte. And she didn't do that. So she's not in compliance with this statute. And when, at the time that this provision was filed, so her complaint now that there's a defect on the pleading, that it falls outside the scope of the court rule and that it falls outside the scope of this provision is erroneous. Because even if you look specifically at the other provision that Ms. Ducklaw stated, which is 1.25530 subsection 3, it says that the duty of to pay rent is suspended, but the monies have to be paid into an escrow account. So defendant comes in here with unclean hands, Your Honor. She comes in here having withheld rent, and the first time she made a complaint is after these proceedings of eviction have started, and it was only after the order of this court that she put her monies in escrow. She cannot now come into this court with unclean hands and try to fix what she did wrong because this court ordered her to do something that she should have done from the beginning. Plaintiff is within his right to bring this action.
Okay.
May I respond?
Just a moment. Okay, so as it relates to not having a certificate of compliance filed with the city, I don't find that the remedy for that is to dismiss this action. So on that point, I'm going to deny the motion. You also allege the property was not kept for tenants' peace and enjoyment required by law. And then also that it was not kept fit for the use intended and never did finish the kitchen update. So I can't rule on that without taking testimony regarding the intended, whether or not it's been kept fit for the use intended, and whether or not it was kept for your client's peace and enjoyment. So I can't rule on that portion of the motion until I take testimony on those matters. So, okay. Now, counsel, your client has stated that the property was not kept fit for the use intended. For example, a bug problem. Okay, so I'm going to swear in Ms. Collins and Mr. Branson. If you can both please rise and raise your hand. Do you both solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. So Ms. Collins, or counsel, Ms. Ducklaw, your clients raised the issue that the property was not kept fit for its intended use. Okay? She cites, for example, a bug problem. I'm not sure if there was any other problems. Okay, not finishing the kitchen. So other than those two issues, are there any other matters that your client is alleging where the property was not kept fit for its intended use?
May I allow her to speak on it?
Well, first I'm asking you, counsel.
Okay. There's a mold issue in the basement causing significant health issues.
Okay, hold on just one moment. All right, so you're alleging it's causing significant health issues.
Your Honor, my client is asking if she can sit down. She's not feeling well.
Okay,
Thank you.
all right, so let's talk about this. All right, so you're alleging a mold issue in the basement causing significant health issues, a bug problem. The kitchen was not finished.
There is a window in the basement that is almost fully detached from the front wall, allowing, a lot of environmental issues like wind, water, rain.
Hold on, let's see. Window and basement. Almost fully detached from the wall.
Yes.
Okay. Okay, what else?
I would like her to continue if it's okay.
Well, counsel, I'm asking you because you're representing her, so I'm
Right.
asking you right now. So what
Okay.
else?
the basement floods, separate from the window issue. There are certain fixtures within the house, such as vents, that are completely detached from the wall.
Okay, I'm sorry. Fixtures
Yes,
detached from the wall,
yes.
and you said such as vents. Anything else or only vents?
There are filters that are broken.
Council, I'm still on the fixtures attached from the wall. Is it only vents? Is there something else that is attached from the wall?
I'm not sure.
Okay. Ms. Collins, yes or no? Is there anything in addition to vents that are detached from the wall?
There
No,
is,
yes or no?
yes,
Okay. What else is detached from the wall?
there is, off the flooring, off the back rail of the steps, there's a metal plate that comes right off. You can just pick it up and fall right through
Is that the wall or the floor?
the floor. excuse me.
Okay, so I asked about the wall.
The
Are there-
vents, all the
Is there
vents.
anything other than the vents that you're alleging are detached from the wall?
No.
Okay. All right. Mr. Clowney, you may continue.
The windows in the basement.
That's already been addressed.
I suppose there may be more than one window with maintenance issues. There is one main window that is almost completely detached from the front.
Okay?
The vents don't close.
Some don't. One room has no heat or air.
Okay?
There is one room with no heat or air conditioning.
Which room is that?
My mother's room. The front
I'm not sure.
is my mother's room. The one used for my mom.
Okay, I don't know what that
It's
was.
the
First
very-
floor, upstairs, where is it?
Upstairs, very front.
Is there only one room in the upstairs front?
Yes.
Okay?
I'm not sure that's an exhaustive list, but that's what I'm aware of.
Okay? Did you send any of this communication over to Mr. Branson's attorney before today?
There have been,
There's also more than just that, yes.
Hold on, ma'am.
there have been, many exhibits filed, but the problem is that I have,
So that wasn't my question, Counsel.
Mhm.
My question is, did you specify these concerns, the ones that you just stated, I understand it may not be an exhaustive list. Did you specify these concerns with Mr. Branson's attorney? Yes or no?
I did not.
Okay, so counsel, let's, actually, Mr. Clow, what's the bug problem? Your client alleged in the motion a bug problem.
Yes, she's having to shower with swimsuits on. The bugs are so intense in her shower. I filed quite a bit of exhibits. Contained within those, there's text message evidence that she's asked her landlord several times to fix the bug issue.
Okay, which page of the exhibits are we referencing on that one?
Okay, one second. Your Honor, respectfully, I have a time limitation today. If we're gonna have a full evidentiary hearing, is there any chance to be able to prepare for that and come back, or no? There's a lot of exhibits.
This is your client's motion to dismiss, so.
Motion to dismiss, yes.
Right, but one of the
Okay,
elements of that is that your client claimed that it was not kept fit for habitability.
Okay,
So I'm trying to, I said I couldn't, make a ruling on that until I took testimony, so that's what I'm doing.
I don't have a specific page number, but these were filed, and that was on Tuesday. May I approach the bench with,
What was filed on Tuesday?
these are text messages,
On Tuesday those were filed?
yes.
I think that, okay, let me,
Was that orange pages?
is there a date on those text messages?
Yes,
Okay, what's the date?
it's, June, July, and August.
June, July, and August, okay?
Your Honor, it's the 102nd page of the document that you filed at 8:03 in the morning on Tuesday, just before the last hearing. page 102, Your Honor.
Okay, I'm not sure if I have that.
There's no bait stamp on there, Your Honor, so that's a problem, that's part of the problem.
Well, let me see, so I'm showing, what I have here is January 31st, and our landlord tenant clerk has unfortunately been out ill. So it's page, okay, but I need to, check to see if Carly, can grab that off and, because I don't see it in my, let me see here, I'm not showing anything here.
Your Honor, it isn't actually, there is a bait stamp on it, there is a document that is, court, like, we have it, it says that it was filed with the court on 2/18/2025. And if I could assist Sister Counsel, the text message is in that document. So if that's the document that you have, you might have the text message that she's speaking of, and it is on around the 100th page.
I have January 31st, I have a date stamp thing, I don't have that one, so
Okay.
if you, I'll take, let me go off the record for a moment, let me check these people in here, and then let me go jump off and grab that to be printed. Just one moment. Record in the matter of William Branson versus Heather Collins, 2402269. And all counsel are present, all parties are present. So the court did step off the bench to grab the exhibit. Is this all exhibit 1?
No, it's exhibits 1 through 9.
Okay, so, and none of these pages are numbered.
Unfortunately, I did not have time and I wanted to submit it before Tuesday's hearing.
Okay,
Your Honor, if I may,
so,
I'm sorry, we just have 2 objections to this, to these.
2 objections to what?
These exhibits, Your Honor.
Okay,
The first objection is the documents were supposed to be turned over in this case by January 31st. And they, on the eve of the last court hearing, produced 105 pages of documents that are not marked. Second of all, if you look through a substantial number of these documents, they reference text messages, which are not the full record of the text message, and they bear no date or time as to when they are sent.
okay, so let me take those one by one. One, the court's going to still allow the exhibits to be submitted because counsel filed her appearance and appeared in these matters after January 31st. So I'm going to give leave for these exhibits to be admitted. Just as though, and there's also been adjourned court dates as well. So as there are other matters that are brought to the attention and exhibits are continuing to be submitted to court, so it's kind of more of a fluid type thing. As the text messages, the objection is noted. I'm going to see if I can voir dire some to try to figure out what it is or not. Where you're talking about the June, July, and August?
Yes, June, July, and August. It's exhibit 5 in terms of the bugs in particular.
Exhibit 5. Okay. Exhibit 5. So let's go to exhibit 5. The first one I have is dated Sunday, July 14th at 10:57 a.m.
The first under exhibit 5 that I filed is from Friday, August 2nd.
August 2nd, why would it not start with July 14th?
They are in reverse order.
Okay, well, I wouldn't start with Sunday, July 14th, because I would presume that that's the way we need to start. So, the first one says, sorry to text so early, those bugs are back in the tub, I seen them yesterday sprayed what I have and they are still there today, these things don't want to die. What type of bugs are we talking about?
Your Honor, there is a page before that.
Oh, okay, well, okay, that shows August 2nd, I didn't realize that would be attached to exhibit 5, I thought, I missed that part, I thought it was only the title, exhibit 5. All right, well, I'm not going to review August 2nd until I'm at that date.
That's, so exhibit 5 is actually in reverse order. So the last page, it starts June 18th, and then the one where it says exhibit 5 is in August. It's the last communication. I do apologize
June 18th.
to the organization.
Okay, well, the back of exhibit 5 for me is September, I don't know, I mean, is there an exhibit 6?
Yes.
Oh, there's exhibit 6, so maybe that's exhibit 6. Okay, yep, that's exhibit 6. So, council, just for future reference, the exhibit page should not have any exhibits with it.
Okay.
So, okay. All right, so going backwards, Tuesday, June 18th,
Correct.
count at 3:43 PM. Does everybody have that one?
Yes.
And, council, if you don't mind, if I just call your attorney Amy, that's a little bit easier to say.
I would prefer that, thank
Okay,
you.
thank you.
My last name is significantly difficult. It's very French for literally no reason at all.
Okay,
I'm trying to get to where you are because I think that when I was going through the exhibits, I may have shuffled them around. But now I think I located, you said Tuesday, June 18th at 3:43?
3:43.
Yes, you're right.
Yes, all right. Also, if you could look, and I'm presuming that the dark background with the light whiting, the light writing is from Ms. Collins, correct? Okay. And then the light background with the dark writing is from Mr. Branson, correct?
Yes.
Is that correct, counsel?
That's my understanding, Your Honor.
Okay. Okay, for Ms. Collins, also, if you could look at these little black spiders, I have all in the bathtub and the bathroom floor tomorrow. When you're here, I appreciate it. I tried to clean them out of the bathtub. Mr. Branson's response. Oh, no. Okay, then there's not anything until Thursday, June 27th at 7:49 PM. Okay, was there any communication between the two of you regarding these bugs after June 18th?
Certainly. Yes, ma'am.
Okay, where are those?
I don't know, but we could certainly.
Would you like to see them? Yeah.
Well, first, if you're asking this court to accept these exhibits, why am I getting partial conversations?
He asked me to take care of them myself.
Okay, that's not my question. Counsel, you've submitted these as exhibit. So this court can view the communication between the parties
Right.
regarding the bugs, and these are an incomplete
Actually, I don't.
transcript, so to say, of the text messages.
I don't. He might have not actually responded.
You might just put your phone away unless the judge asks you.
Was there additional communication after June 18th and before June 27th regarding the bugs?
I can't recall.
Mr. Branson,
Yes, ma'am.
okay. Do you have those on your phone?
My phone is in the vehicle because of the situation that's been going on with phones.
Okay, so that wasn't my question,
Oh,
sir.
I'm sorry.
Do
No,
you have them on your phone?
yes, ma'am.
Your Honor, I'm sorry, I don't mean to interrupt you. I think our administrative assistant has them and she can put them on the screen for you if you'd like.
I object. I need to be able to review exhibits in advance.
Well, counsel, you've offered the text messages between your client and Mr. Branson as a way for this court to determine whether or not there's an issue of habitability and the property was kept fit for living, and I have partial conversation here. So I need to have the full conversation. So this is new for everybody because, well, your client has everything printed up. Or do you have those printed up, ma'am?
I'm going to look if they're in here. If they're in this file.
Your Honor, she has them and she
Okay,
did.
counsel,
They might not be in this
I'm-
file.
we're not gonna have any communication right now until we see if these are in here.
Judge, I'm just gonna stand up because my back hurts, I apologize.
That's fine.
I said too long, it's painful.
Your Honor, I have more complete communications from earlier in July, the 13th and the 14th.
I'm looking for June, between June
Oh,
18th
I'm sorry,
and
yes.
June 27th.
Okay. That's July as well. Just looking for between June 18th and June 27th.
Okay, while you're looking for that, I'm going to handle a couple of matters, okay? Or June 18th and June 27th?
I obtained a more comprehensive view. It's still not clear what the entire conversation is.
Well, here's my question. Why am I receiving as exhibits partial conversations?
That's a good question.
Ms. Collins?
Just to show that I sent that there was a bug problem.
No, hold on. But Counsel, you've submitted these, right?
Yes,
Did you look at them before you submitted them?
I did, yes.
And did you notice that there is a huge gap between June 18th and June 27th?
Yes, and I was anticipating, laying a foundation and questioning a witness.
Which witness?
Both Mr. Branson and Ms. Collins.
Okay. Did you show Attorney Amy? I'm very elementary when I say that, but I'm very sorry. Have you shown Attorney Amy, though, that
Not yet,
has a list?
no.
Please show that to Attorney Amy. I'd like to take a look at those. I'm not necessarily going to look to read them for any substance, because obviously Attorney Amy has not had a chance to review these. However, I'm trying to, doesn't even have dates on here. January 23rd, oh, that's the date it was screenshotted or something? I don't know what this even means.
In Your Honor, if I may, just for the record, if you look to the far right-hand column of the thing, that's the first time a date appears, and it appears to be at June 9th.
June 9th, June 10th. There's also Monday, June 10th. Okay, that's not even the relevant time frame.
Your Honor, I can point out the text message where it starts on Tuesday, June 18th, which is separately submitted. Yeah, it's the same text message.
That's not, okay. If text message conversations are going to be proposed for an exhibit, and this court is being requested to rely on the text message conversations to prove something that you're alleging, I need a full and complete conversation, not piecemeal. I'm not accepting those if they're piecemeal. Mr. Branson,
Yes, ma'am.
your testimony is that you have these on your phone.
Yes,
Okay,
yes,
your phone is out in your vehicle?
yes, ma'am,
All right. Please go out to your vehicle to grab your phone.
yes, ma'am.
Thank you. All right, while we're doing that, I'm going to handle,
On text messages between parties.
okay, so I'm going to ask this. When you get to that point, I'm going to handle one more on the record. When you get to that point, Counsel, if you can show Ms. Teklala, so if the two of you can go out into the lobby for that so that it's not pulling on the record, okay?
I have to object, because you can go into a phone and line item delete text messages.
Counsel, I'm very aware of that. I just right now want for you, the two of you, to see if those exist and to look at those right there,
Okay,
okay?
okay,
And ma'am, we will then determine whether or not you have any different ones on your phone. We're gonna do this piecemeal, okay? That's how we're gonna do it, step by step.
Your Honor, if I could just make a brief argument regarding this. The defendant is claiming a defense to this eviction proceeding with her motion to dismiss them. She carries the burden of proof in this case to prove what she's saying is true. My client carries no burden to prove her case and defend himself against her case. Defendant came in here today utterly unprepared. And quite frankly, I believe that she came in here with the intent to do trial by ambush by providing intentionally only piecemeal copies of these text message records.
Counsel, I'm aware as to where the burden lies as far as this motion to dismiss. Right now, I'm not necessarily stating that I'm looking to see the truth of anything within these text messages. Right now, I'm trying to verify something. So
Thank you.
please, if you will just please humor me and follow this exercise.
Of course, Your Honor.
Okay?
Thank you.
And June 27th.
yes,
Okay. And are there text messages between the parties on those dates regarding the funds?
There are several text messages.
Are there any regarding bugs?
Yes,
Okay, now, I'm going to have you all go out there with Ms. Collins's phone, have her turn on her phone, get to that date, and you still have Mr. Branson's phone, correct, Miss Amy?
I did, Your Honor.
Miss Amy, now I feel like I really am.
I actually prefer that. I like Attorney Amy with Amy.
And, so, please take Mr. Branson's phone out with you, counsel. And then you can compare the two phones to see if there's any messages that are not there, okay?
All right,
thank you very
Thank
much.
you. Is on the Branson versus Collins matter, when both counsel were comparing the phones.
No, Your Honor. No.
Okay, very good. Are any objections to the court reviewing the text messages, since now we know that there are not any missing text messages between those dates?
Your Honor, I have no objection about reviewing the text messages. However, I would say that it is not, we reviewed what you've asked us to review, which is between July 18th, June 18th, and June 27th. However, there are other text messages past that date that are relevant to this conversation about the bugs, including text messages where the bugs have been completely eradicated.
Okay, and I'm not saying that we won't, I just wanted to get those dates, the messages between those dates secured. Are the messages regarding that Counsel Amy is referencing, are those included in the documents that were submitted?
No, I'm not aware of that,
You're not aware of what?
the eradication of the bug issue.
Okay, whose phone are those on?
They're on my client's phone, but they should be on her client's phone as well.
Okay, good, I'm gonna have the four of you go out into the lobby and compare those.
Sure.
Thank you. So, Terry, can you give me the last one? Can you give me the last one, Counsel? Okay, so we are back on the record in the matter of Branson versus Collins. And so, counsel, you both had an opportunity to review the subsequent text messages after June 27th, correct?
Correct. That is not correct, Your Honor. The defendant walked away and did not allow me to actually look at her phone. She literally walked away from the conversation. And
Don't interrupt, please.
And I asked her counsel whether or not there were text messages subsequent to the one that we have on August 18th. We have not been able to, because we have.
August 18th?
Yeah, so we have a text message specifically on August 18th. Hey, the guy came out, he sprayed, this should take care of it. She says, thank you. That's the last text message my client has related to any book issues.
All right, okay. Do you have any of those text messages, ma'am?
Yes, sir.
Is she allowed to be using her phone at this moment?
As long as she's just looking through her text messages. So, Mr. Klala, did you see on your client's phone the part about the bugs being eradicated and your client saying thank you?
I saw that conversation. I don't consider it proof of any eradication of the
That
bug
wasn't my
issue.
question.
Okay, I saw what you're referring to.
Okay. Did your client allow Attorney Amy to view the text messages that you were viewing?
No, but that was an accident, Your Honor. She walked away. I thought we were just confirming that they both had that text message.
We were, but, well,
Okay.
you were, the two of you were.
Mhm.
How is Attorney Amy supposed to do that if your client walked away with her phone?
Okay, yeah, you're absolutely right. I'm sorry.
So the message that somebody came out to spray for the bugs and your client saying thank you, that doesn't mean that those were eradicated.
No, they weren't. There's still a bug issue.
Okay, when did your client then re-notice Mr. Branson regarding the bug issue?
I have to ask her the specific date if she could recall it.
Okay, here's some concern that I have here. Your client is alleging this matter should be dismissed because the home is not habitable, okay? Or it's not fit for living properly. Did you find the text message? Don't stop looking until you find the text message, please. And you've submitted a plethora of text messages that are incomplete. So I should not have to be the one to essentially babysit step by step how the evidence should be brought forth and communicated between counsel. I should not have to do that. But yet, I am. having to do that.
Yeah,
Because your client has given you partial information. I don't know if you've attempted to get the information from your client and it's not able to be given to you at the time you're asking, I don't know. But to ask this court to dismiss this matter,
They didn't say they were eradicated.
what does it say? Is it right there?
Yes.
Okay, show Miss Amy what that is. Attorney Amy, the phone.
They said they're harmless.
That's August 18th?
Yeah, that's not if you'd like, Your Honor, I'll read the entirety of the text message into the record and they can confirm whether it's accurate or not, if that's.
Is that,
This is August 18th.
Yes.
Never. Did they say they're
ma'am,
eradicated?
I'm
They
not
said
asking
they're
for your
harmless.
testimony. I'm asking if you have pulled up the text message
Yes.
that is being referenced regarding
Yes.
somebody coming to spray for the bugs and you saying thank you.
I didn't say thank you, but yes.
Your Honor, the
But
very
yeah, I
next
did
time.
say thank you. You're
Yeah.
right. I did say thank you.
Okay, so I'm going to have you follow along on your client's phone. Attorney Amy, please read into the record
Thank
the
you, Your Honor.
date and time and who it's from, please.
Thank you, Your Honor. From Mr. Branson to Ms. Collins on Sunday, August 18th at 2:40 p.m. He identified the bug as a springtail, basically like a gnat. They don't bite, sting, do anything. Totally harmless. They like damp areas. He recommends every time you shower, use the vent. The underside of the tub is totally dry when we ran a camera under it. Sprayed for them. Google springtails. This should take care of them. Hung the mirror and your doorbell also. I ordered some LED lights. It says LED, but I take that to mean LED lights for the basement as well. And untimed response by Ms. Collins. Thank you so much. When you have a moment, can you please show me how to take the doorbell off and I can hook it to the Wi-Fi and app. Sorry I tried and I felt like I was going to break it. Also, the mirror looks great. Thank you so much. I appreciate it. And then there's one response by my client on the sheet that I have that says there's a small orange tool in the box. Use that to unscrew the set screw on the bottom of the doorbell, then slide it up.
Okay. Did you then send, so that sounds to me as though, Mr. Branson fulfilled his obligation at that time as it relates to the bugs. Because he had somebody come out to the home, sprayed for the bugs, determined what type of bug they were, determined that there weren't any leaks because underneath the tub was dry, indicated what type of bug it was, and that it's a bug that, it's a harmless bug in the sense that there's not any, I presume like a bee or something like that, where it would be stinging or something. And that what type of areas that particular bug likes. Now, did the bugs return?
Yes.
What date?
They've been returning off and
No,
on.
ma'am, it's your
I
burden.
don't know the exact date.
Ma'am, it's your burden. You have filed a motion to dismiss and you're alleging that there's bugs and that that's a reason why Mr. Branson should not have checked box number 7. So what other dates have the bugs returned that you communicated that to Mr. Branson?
I can't give you an exact date, so I'm not gonna lie and make one up,
Okay?
if that's what you want me to do.
No, it's not. I don't want you to lie and make one up. Okay, so we'll move on from the bug problem. The kitchen not finished. What's wrong with the kitchen?
When I moved in, I was told that I was gonna be getting a whole brand new kitchen. I was shown their kitchen. When I was walked through to look at it, when I moved in, they said, this is the kitchen you're gonna get. I was given, you're gonna have cabinet doors, brand new flooring, everything. And I said, oh, great. They even said, because there's originally one price on Zillow, they said that it's gonna be $1,500 when you move in because we're doing this kitchen.
Hold on. What was the amount on Zillow that you originally were going to rent the property for?
$1,300.
$1,300 a month.
Yes,
Mr. Branson, is that what the original rental price was $1,300 per month?
it was also on Biddle
Ma'am?
Street.
Hold on. I'm talking to Mr. Branson right now.
Honestly, I don't believe so. I don't have the Zillow thing. My wife puts the Zillow on and.
Okay.
No, the agreed upon the lease was 1,500. I don't believe it was, or 13. I'm not gonna say in
Okay.
confidence because I don't know what the Zillow.
Did you at any point increase the rental price based upon a new kitchen?
Absolutely not.
Okay. Did you take Miss Collins into your home to show her what kitchen she would be receiving?
She's been in our home, but not for that reason, no.
Okay.
No.
Is there a working kitchen in the property,
Oh, absolutely, yes.
Miss Collins?
Yes. But to be fair, the outlets don't work. For the first 3 months, if I used just one appliance, the entire kitchen wouldn't work.
Okay. Did you notify Mr. Branson of that?
Yes, I did. And then December 1st, when I found out one of the outlets was start fire, I let him know.
When did
and-
you find out an outlet would start fire?
On December 1st, I went into the hospital and I said, could you fix the outlets? I'm in the hospital, I'm out. He said, okay, I'll go in, you're in the hospital. When I went to try it in November, when I got out of the hospital, I was finally up and I was able to try it on my own. The first time I did on December 1st, I let him know. He rushed over on December 1st, I have it on videotape. He said, well, if it catches on fire, I need to know, and he came into my house, and he was, well, I'm evicting you.
Hold on. If he says if it catches on fire, let me know, doesn't mean that it's an outlet that's going to catch on fire.
No, it's, right, it smokes if I plug something in. So he comes over, cause I
It
said,
smokes?
yes, I have an
Which
outlet,
outlet are we talking
the
about?
one in my kitchen,
I understand that, ma'am. Which specific outlet?
the one by the back door.
Okay. So, Mr. Branson, the outlet by the back door,
Yes, ma'am.
does it work?
Yes, it works. I mean, she's plugged appliances. There's no evidence of a fire. We have replaced that GFI.
When did you replace the
The
GFI?
first time she complained about it, we replaced and put a brand new GFI.
Okay, what date was that? Okay, what month?
It would have been right after she made the complaint.
I don't know when that was.
I'm sorry. I don't know when her first complaint about the GFI was.
Okay, would it have been summer
No, I
or winter?
believe it was in the fall, actually.
Okay, so before she went into the hospital?
She's
Or
been
while she was in the
hospital. I'm sorry. No, she was in the hospital when I did that. Yeah.
Okay, all right, so the GFI was replaced. Would you agree with that, Ms. Collins?
While I was in the hospital, correct?
Okay. And then your testimony is that even after it was replaced, it still didn't work,
Correct.
okay? Well, the inspection next week will take care of that. And,
Your Honor, there's a,
and you said that there were 3 other outlets that did not work. Where were those? Where are those?
There's one, in the dining room that does not work at all.
Okay, you said the kitchen, there are 3 in the kitchen. Is it an eat-in kitchen? Or is there a separate room for dining room?
There's a separate room in the dining room.
Okay, so we're talking about specifically the kitchen.
Oh, there's another one in the kitchen well, the kitchen, if you were to plug one into the other, then the whole kitchen goes out.
Yeah, I don't know what one into the other means. I need you to be specific for the record, okay? And I also am asking you, you said there were 3 outlets that do not work. Where are those 3 outlets located?
There's, well, the 2 right there that I was talking
Ma'am,
about,
okay.
that start,
Hold on. You keep saying right there. I don't know where right there
the
is.
one by the back door.
Okay, there's 2 by the back door?
No, I'm talking, to me, 2 outlets are the 2 plugs right there that are together.
Okay, so it's 1 outlet, 2 plugs,
Correct,
not 2 outlets. Okay, so it's 1 outlet with 2 plugs.
correct.
Is there another location in the kitchen that the outlet with 2 plugs does not work?
No, that one, that's
That's the only
yes,
one?
that
Okay,
I know of.
okay. So what part about the kitchen does not allow for the home to be fit for its intended purpose?
What I was talking about with the kitchen, ma'am, is they baited and switched me with the kitchen. And I have proof of that.
Okay, what's your proof of that?
My proof of that is text over and over, and then in the hospital, they finally said,
Okay, where are those text messages?
can I show you on my phone?
Well, are those included in any of these exhibits? Because we have 105 pages of exhibits, which which I'm presuming, since the kitchen is an issue, that it's going to be in here somewhere.
I know, I gave them to her to submit.
While she's looking, if I may, Your Honor, just a
Yeah.
brief
The
argument.
fridge and stove are coming
Oh, hold on,
in.
ma'am, I'm asking you to look for them, not read them right now.
Thank you, Your Honor. Even if what Ms. Collins is saying is true, which we disagree with, it doesn't make the kitchen uninhabitable. It doesn't make the house unlivable to the point where she can evade any form of rent for that. Moreover, every conversation that they had about like possibly remodeling the kitchen was put off because Ms. Collins indicated she had cancer. And they didn't want to go in and do a major construction project while Ms. Collins has cancer. And if you look at the entirety of the text messages, which she did not submit again, that's what you'll see. You'll see that there was a conversation about possibly remodeling the kitchen and it being put off because Ms. Collins had indicated to the Bransons that she had cancer.
Okay, so, yeah, when was there a conversation about remodeling the kitchen?
The remodeling in the kitchen was, they're supposed to be done before I even moved in because I signed the lease May, I believe, 24th. I didn't move in until June 17th. It was supposed to be done before
So hold
that.
on, but I think I saw somewhere that you were dropping things off June second, so you had access to the
Totes
property.
upstairs.
You had access to the property June second, so whether or not you moved in fully after that, I don't know, but you had access to the property before
Just
that.
totes. I
So
couldn't think
I recall from the last time, from 2 times ago, that you made the argument that you were not in there for the full month of June, so you should have the abatement for certain dates of that. You had
June 3rd.
access to the property, and you moved some items in June second. Whether you moved the rest of them in or not after that, absent some reason that stems from the home not being ready to move in, I don't see that that's a basis to abate any portion or prorate any portion of June. However, the kitchen being remodeled or not being remodeled when you're told it would be remodeled, if that's what the conversation was, and it wasn't remodeled, I don't find that that would be a basis to find the home not fit for habitability. And was there a discussion to raise the rent after the kitchen was renovated?
No, ma'am, absolutely not. I've never raised the rent. I had no intentions of raising rent.
Okay. Ms. Ekbal, what you have there?
Exhibit 6 contains text messages about the kitchen.
Okay.
Your Honor's probably not gonna love it because it's the similar format as before.
Well, you're correct.
July
24th.
Also, I'm at a little bit of a loss. I thought we were arguing a motion for summary disposition based on the certificate of occupancy. So I was intending to call witnesses for a, evidentiary hearing and cross-examine them and lay a foundation for these exhibits for those underlying issues.
Your Honor, I warned opposing counsel that she was mistaken. I gave her fair warning via email, in writing. I think this court is actually purview to those conversations. I think they have happened in line with the conversations related to the proposed order that Your Honor had the ability to view this morning. And instead of double checking and crossing her T's and dotting her I's, Ms. Ducklala came in here unprepared for this hearing after submitting documents that are inappropriate and abjectly in violation of the Michigan court rules and rules of evidence.
Your Honor, I'm a little tired from opposing counsel trying to throw the evidence under the bus and say this, that, or the other thing, when all I'm saying is there's procedure to be followed for a motion for summary disposition based on immunity granted by law compared to a full evidentiary hearing while I'm calling the witness.
What immunity are we speaking of? Because because the court ruled on, in fact, let me pull it up. The court ruled when the parties were first here on the 14th that Ms. Collins was going to be relocating. She, number one, stated she wanted to relocate, and the court ruled that the plaintiff is entitled to recover possession of the property. What I ordered the parties to brief was the issue of where the money that's held in escrow is to be released based upon two things. Number one, your client, indicating that she didn't have access to the property for the month of June or couldn't move in until June 17th, so she wanted a prorated amount. Also, because your client alleged that, that the certificate of occupancy plays a role in where that rent money that's been deposited in escrow goes. You subsequently filed an appearance, let me just see something here. That was on the January 14th date. We set this for an in-person trial for February 7th. And that's when the court entered the escrow order as well. Then on February 11th, because I must have gotten removed February 11th. February 11th, the hearing was held. We adjourned for the next hearing to address the issues. June 2024 rent, defendant claiming she overpaid utilities, plaintiff going in all hours of the night, stealing mail harassment. Also, parties to brief the issue of no certificate of occupancy and collection of rent. Then we moved into the 18th, and I had originally stated the wrong time. And then the parties were here on the 18th, except for Ms. Collins. She was present earlier, even though we had noticed everybody that the time was changed. And we adjourned the matter today regarding the escrow money and utilities and two other issues that the court stated. You also, counsel, at that time, wanted to address your motion, amended motion to dismiss. So that's what we're still on. We're still on the amended motion to dismiss. I started with that because if I'm granting that, then the rest of the matters appear to be moot as far as that goes. However, so that's where we're at right now. So that is what we're here for. So as it relates to the kitchen, what does that state? What is that? And I will also make a statement regarding the evidence. And counsel, you've submitted evidence that is incomplete. You've submitted these exhibits that are incomplete.
I suppose I was just looking for clarification from the court why, to me, this is a motion for summary disposition under 2.116C7 and C8. It's not an evidentiary hearing, so I have testimony, and to not be able to, take testimony of someone that I'm calling with evidence that I can build a foundation for, it's just procedurally, I can't understand. I do understand that you're allowing, and thank you, allowing to hear argumentation on habitability for the number 7 that was checked. I do understand that and appreciate that.
A motion for summary disposition wasn't filed, so this is not a summary disposition matter. A motion to dismiss was filed by your client. An amended motion to dismiss was filed by your client. You're relying on that motion that was filed and then submitted additional exhibits. So we're back to the kitchen.
Could you do me a favor and give me the court rule for the motion to dismiss?
The court rule?
Yes.
Your client filed the court, I don't know what she filed it under.
I don't think she filed it under any court rule.
Well, then I guess, you're claiming that it's, let's see here, property item 7. That is what she referenced. Or, I'm sorry, item 7, non-payment of rent for residential property, item 7.
I'm just asking for the court rule so I can have some guidance in terms of the motion to dismiss compared to my interpretation of it substantively was more of a motion for summary disposition. So if I could, if I had the court rule for the dismissal that we're operating under, maybe I could have more clarity there.
Well, presumably I'm operating under 2.119, which is a motion, and your client filed a motion to dismiss. 2.116 is a motion for a summary disposition, and there has to be a 28-day notice, and there has to be a time for response to be filed, affidavits, and all that. This was not filed as a motion for summary disposition. This was not filed that way. So we're proceeding as a motion to dismiss.
I don't believe she filed it in the first place. I filed a brief.
Who filed the motion to dismiss, this handwritten motion? Who filed this motion?
That is an exhibit. It wasn't filed. You had ordered briefs. And she had
No,
written
this-
that before.
No, this was filed.
Oh, my apologies.
This was filed.
Okay.
Prior to your appearance, counsel, this was filed.
Mhm.
Because this is what we did not proceed on February 7th, because there hadn't been sufficient notice to plaintiff.
Okay.
So that is why we are handling it in its entirety now, because now everybody's here, everybody's present, that is what we're doing. So, but if you want to stipulate that the property was habitable and we don't need to have further inquiry regarding item 7, then we can proceed with the next issues, that's fine. Or we can continue to proceed with whether or not the property was kept fit for its intended purpose pursuant to number 7, the complaint for recovery of possession of the property.
Okay, I would like to request a continuance, please. For the reason that I was under the impression we were arguing in terms of the disposition of this case under the law in regard to MCR 4.201 and MCL 125.530. I'd like to re-subpoena the witness that I had subpoenaed for Tuesday's hearing in order to have her present.
Which individual is that?
It is Kelly Roberts. She works for buildings for the city of Wyandotte.
Okay, you subpoenaed her to be here this past Tuesday?
Yeah,
Was she here?
no, she wasn't.
No, she was not. Okay, so what does Ms. Roberts' presence or testimony, what's the relevance regarding the motion to dismiss?
I want to ask her about any former inspections of the property.
That would be as it relates to the money held in escrow as to where that goes, but I don't know that I need her testimony for that, but that I'll defer that for just a moment. What does that have to do with the motion to dismiss?
What it has to do with the motion to dismiss is, again, going back to how this is a little convoluted in my brain, because you have MCR 4.201, which dictates that residential properties have to be kept fit for their intended use and purpose, and habitable as it relates to number 7. Then you have MCL 125.30. So to me, if there's no certificate of compliance, and then on top of it, factually, it's not being kept fit for use, especially with the amount of evidence and the amount of issues. If I have testimony from a city employee stating that there's a history of problems at the residence, or some further information that could push the burden of proof so I can actually get my client the justice that I'm attempting to get now, that's why I'm asking.
If I may briefly respond to just her oral arguments,
Okay.
if it may please support. First and foremost, my client has been delaying this. Like, this has been pushed out a number of times, like a multitude of times, and we're here today. Client's mistake of what was going on because she misunderstood the nature of summary proceedings as opposed to a summary disposition motion. I don't think it's good grounds to continue to delay this. This court has already ruled that this tenant must leave the property, and now it's about where the money goes. The defendant has the burden of proving whether or not there should be some money released to her or all of the money should be released to her. That's her burden. And she came without evidence. Even the evidence that's in here is not relevant. Moreover, the witness that she was trying to call from the building department as it relates to habitability is not necessary, nor is it relevant, because the past history has nothing to do with what's going on today. Has nothing to do with what's going on today and the actual condition of the property as it sits today, Your Honor. So that witness is irrelevant. And the reason that witness didn't show up last time is because Sister Counsel subpoenaed her incorrectly. A subpoena was submitted to the city via email 3 days before the hearing, when the court rule clearly requires 7-day notice with personal service of a subpoena for a witness to appear. So Sister Counsel didn't even do that correctly to get her witness here. And she could have, she could have subpoenaed her for today, but she made no effort to do so. And if her claim is that this witness goes to where the money goes, that issue is before the court properly, because even if we're not having the full proceeding today, that issue, the specific issue of where the money goes after this hearing is over and you make a determination of habitability, would have happened today pursuant to the defendant's own motion. And it is further clear that the express language of the statute that we're talking about, which is actually MCL 125.528 or 125.530 subsection 5 dictates where that money goes. And the money is supposed to be held by the city. And the money is supposed to be released to the plaintiff for the purposes of completing repairs due to the express language of that statute. And after whatever's left over, after he has been reimbursed for the repairs, is intended to be released to the landlord. It is clear. The statute is clear and unambiguous in its terms that is what happens with the money that is held in escrow, Your Honor. So that witness would have been more appropriately here for the motion to dismiss, and as it relates to the issues that were brought forth by the defendant in her motion, and she's not here today. And that witness is not relevant to move forward to proceed on the issues of habitability, Your Honor, because that witness has not inspected this property.
I sent an email to the witness as a courtesy. I sent it out, priority mailing, but I was retained 4 days before this was. I'm just a little tired of hearing, I didn't do my job, I didn't do my job, I didn't do my job. When I'm not talking about that. Yes, there's a burden of proof. Yes, there's evidence. I'm talking about being able to fairly get testimony from the witnesses I intend to call and to be able to lay a foundation for my evidence. Because a lot of this is trending into what my client's defenses are. It's not relevant to the motion to dismiss, it's what her defenses are.
Okay, what are your client's defenses?
Well, my client's defenses obviously primarily is that it wasn't fit for use and habitability.
Okay,
It's necessary.
so your client is stating that when this complaint for non-payment was filed on January 3rd, that the property was not in a habitable condition.
Correct.
Okay. So you subpoenaed Ms. Roberts, you're intending to call Ms. Roberts as a witness to address the habitability of the property.
Correct.
Okay. When did she go in to look at the property?
I don't think that she has.
So then how would her testimony be relevant?
Because she's the custodian of records for the buildings department.
Okay. But if she has not looked at the property, how can she determine what issues would affect habitability?
I would be more than happy to talk about what issues affect habitability after the inspection is done that's scheduled on Wednesday. But I'm absolutely insisting that someone from the city provide testimony related to this property.
Okay. Has the property been condemned?
No, Your Honor, it has not.
Okay. So have there been citations issued to Mr. Branson regarding property maintenance violations?
No, Your Honor, it has not.
Has there been any documentation that would suggest that the property in and of itself is not habitable?
No, Your Honor, there hasn't.
Ms. Teklala?
So I have significant evidence from my client. There are several pictures that have been submitted to the court.
Okay, let me clarify. Any of those photos, do those render the premises inhabitable?
Yes, the mold issue.
The mold issue, okay. When did the mold issue begin?
Before I moved in.
Okay, did you look at the property before you moved in?
Yes, and I asked him, he told me it wasn't mold. And he
Okay, did you have a mold test done?
No, I believed him.
Then how do you know that it's mold?
No, I've now since.
Okay, where's the mold test?
I'm getting it back right now, and I'm also.
When did you
getting
have
it
the
home.
mold test completed?
About 3 weeks ago.
Okay,
That's the thing, Your Honor.
which photo is alleging the mold? Let me get to that. Which photo is alleging the mold? Look at the mold.
Judge, may I? I think I can help the court.
What's that?
The photographs provided by the defendant in this case are all black and white. It would be absolutely impossible for you to look at those photographs to make any form of determination.
Oh, is this where Miss Ashley comes in, where she's got color
That's right.
photos that she's gonna screen share?
Not like color photos, but we have the body cam. And we've been able to, the body cam for the police is extremely
Does the body cam show any of the alleged mold spots?
I believe it
No, no, I'm not
does.
asking for belief, I want to know, does it?
It does,
It doesn't show any mold spots because no mold spots exist, but
Okay.
it does show the general condition of the area in which, this defendant claims there is mold.
Okay, Ms. Miller, I really need for you to please stop talking Collins, while somebody else is talking, because it's affecting the record. Okay, and I'm having a hard time focusing on what's being said, because I'm hearing you talking, I don't know exactly what it is you're saying, but I'm just hearing noise that way. So, where are the photos? So the photos had to come from somewhere, were they on a phone?
No, and I do have color copies.
See the color copies, please.
I have black and white here.
Well, then why don't we have the color copies here?
Because I need a continuance, I need more time to adjust my exhibits and to be able to run this effectively.
Well, if there's an allegation of mold, I'm not sure why the color copies weren't brought. Was it on somebody's phone?
No, what?
Your phone?
Yes.
Okay. I received actual printout pictures, that's why I said no, I wasn't aware of it.
Okay. Okay, ma'am, I'm just looking for you to pull up the pictures.
They're all in different spots, so I have more, they're in three
Pull
different
up
spots.
one, pull
Okay.
up one for now.
I'm trying to find the best one. Here's a good one.
Okay, show it to council. Okay, Terry, can you facilitate, please?
That's the black one.
I'm not asking for additional comments, I just want the photo, please. Okay, so this is, looks like, okay, where is this photo taken? What room?
In the basement.
The basement. Okay, is it, this looks like there's brick and then maybe cinder block? Okay, okay, this is on the block itself. Is there anything on the walls? Is there any drywall in the basement?
No, Your Honor.
Yeah,
Yes,
there's drywall as well, yes.
there's drywall. Is there drywall in the
No,
basement, Mr. Branson?
No, it's an unfinished basement.
Okay, ma'am, do you know when I say drywall, I'm not speaking of whether or not there's a wall that's dry. Drywall is it's a material that people put over 2x4s or whatnot to create actual walls in rooms. So, is there any drywall in the basement? No? Is that no?
No.
Okay. All right, well, is there another,
Your Honor, I have a photo that was submitted in the exhibit, so it is black and white. But you can see a significant spot that could either indicate the leaking itself or the mold, which may go hand in hand.
Your Honor, even if it shows either or, like counsel's own statement is an admission and you can't tell what it is. And let me say this.
I'm gonna look for, grab another picture, please, that shows more of the wall itself there, please, and not just a close-up of the spot, please.
And let me say this, Your Honor, my client purchased in the summer, last summer, a dehumidifier for the basement. It's been running full-time, and if there's mold in the basement, let's ask Ms. Collins why she has the basement floor filled with her personal belongings, because everybody knows that if there's mold in an area, the spores will get on your belongings. So she is storing her personal items in a place that she's claiming is filled with black mold. It's inconceivable. It's irreconcilable with her current statements.
Okay, why, does your client have a dehumidifier in the basement?
Because Ms. Collins had said that it smelled musty. So because it smelled musty, he bought a dehumidifier in the basement, just to appease her, to make the damp smell go out of the basement.
Okay.
Moreover, it's very clear that Ms. Collins did not order a mold test until we were well into these proceedings,
Okay,
Your Honor.
so, Ms. Collins, is that, what did you take a screenshot of?
I'm just showing it closer.
No, I didn't ask for it to be
Okay,
closer.
that's fine.
Show the picture that you just pulled up and you took a screenshot of. I don't want the screenshot, I want the
I'm gonna delete
picture.
the screenshot. There you go, right here.
Please show, Terry, please
There you
show
go.
council.
I'm gonna get it so it's not cropped or anything, hold on. There you go.
can we show the historic plan?
Yes, I don't even, what is this a picture of? Where is this picture?
He has, before I moved in, he had, shelves blocking a window. The window I'm saying that's like almost falling off, he has a shelf holding that window
Okay,
in.
these are behind, this is behind the shelving?
Yeah, that's behind the shelving.
So what part of this are you referencing is the mold? The part of the
Right
bottom
down, yeah, right, all down by
by the
there.
shelf?
Yeah, he's trying to hide it.
Well,
He has stuff on there, behind there.
Ma'am, hold on. That doesn't necessarily show that that's mold. It shows that it could be dark brick or discolored brick. I don't know that. Can you please show that to Mr. Branson?
He has stuff.
Ma'am, when did you become concerned about the mold that you're alleging?
After I got out of the hospital, and they told me that it could be something in my house.
What could be something in your house?
That gave me my disease.
What disease is that?
That I have this low vitamin thing that my body's not reproducing.
Okay. Okay, well, when did you get out of the hospital the last time when that was stated to you, ma'am?
In October,
Okay.
last week of October.
Okay, and so you ordered the mold test 3 weeks ago?
With my doctors that finally put it to me, I first smelled something when I first moved in and he's like,
Right, that's why you have the dehumidifier.
yeah, that's why I put it in there.
Okay, right, and that's
But I was
established.
never aware, I was never told until like 3 weeks when I moved in that the basement flooded. He sent me a text, oh, by the way, the basement floods.
Okay, hold on. Does the basement flood, Mr. Branson?
No, ma'am, not at all.
Does the basement flood when there's heavy rains?
Absolutely not.
Has the basement ever flooded?
No, ma'am.
Did you ever tell Miss Collins that?
May I address?
Did you ever tell Miss Collins the
No, ma'am,
basement
no,
floods?
I've never told her the basement floods, because it does not. I have an adjoining basement, and I have no flood, never have. I've lived there since 1977, and I've never had a flood in that basement.
Okay, and at what point did Mr. Branson tell you that the basement floods?
Within 3 weeks of moving in.
Did the basement flood within those 3 weeks?
The first time it got wet, yes. It was
It got wet, what does that mean?
The walls got wet and the ground got wet.
Okay, did the ground get wet near where the walls got wet?
Yes,
And would that wall be near where the window is, needs repair?
yes.
Okay. So, okay, at any point during any of the heavy rains, did you have water covering the entirety of the floor of your basement?
Not.
Yes or no?
No.
No, okay. So it's quite possible that there's some leaking water from the window, that went down the wall and on the floor there, that's possible. Okay,
Your Honor, Exhibit 7 is a screenshot of a text message from July, and it tends to indicate that Mr. Ranson did know of the flooding in the basement.
hold on a moment.
Sure.
Exhibit 7.
In fact, Your Honor, it actually says exactly what Mr. Branson said, that the basement has never flooded. But it says, hey, if it's wet down there, let me know, but it's never flooded. Literally, that's what it says. Despite the ill-conceived reference that Sister Counsel would like you to make.
Possible.
There's nothing in
Hold
it.
on, I can't even find that yet, hold on, I don't even, oh, there we go, I'm coming close, okay. All right. Sorry for the, okay, Tuesday, July 9th at 10:59 PM. Sorry for the late text, but with the possible heavy rain, make sure you let me know if you're getting wet tonight or tomorrow. And then, Ms. Collins responds, would that be in my room or the basement? Sorry if we just get, and then it cuts off. And then there's nothing else after that.
Yeah, because
And then and I will note that there's a handwritten note on here, which there also shouldn't be handwritten notes attached to exhibits that said new basement floods before I moved in with a question mark. So,
And Your Honor, the reason she cropped that is because the next text message chain, which me and both Ms. Davala were able to view when I was scrolling through my client's phone, clearly states, no, it's never flooded. Like, it literally says that. That's why she
okay,
cropped
did you
it out.
both review that, Counsel?
I was looking at the bug problem, so honestly, I, probably should have been paying attention more. But
Okay, well, I mean, you're focused on them, that was the
Yeah.
purpose of looking was for the bug problem. Okay, where's that message?
We're pulling it up, Your Honor. Your Honor, can you give us the date of that again, please?
July 9th.
That's not right, but that's because he's calling it.
Okay. So, all right, so council, you both looked at this, correct?
Yes, Your Honor.
yes,
All right, so, okay, starting Tuesday, July 9th, 10:59 PM, from Mr. Branson, sorry for the late text, but with the possible heavy rain, make sure you let me know if you're getting wet tonight and tomorrow. Miss Collins, would that be in my room or the basement? Sorry if me just getting home woke either of you. Mr. Branson, basement, we have never had a flood, but it's supposed to get nasty. You didn't wake me, I'm on a call for work, so up all night, and I just realized wording and apologize. Miss Collins, never apologize, it shows you're a great landlord on top of things and want the best, also don't want the worst in long term. I will watch out, we have to do laundry anyways, and was unpacking a little to get ready for Sky. Okay, and then they talk about Sky, which I don't think is relevant, since I don't even know who Sky is, but anyway. So, it acknowledges that there's not any flooding, but since there's going to be a lot of rain, he wanted you to look for that, I don't know, but it acknowledges I don't find that there's flooding in the basement. But I still haven't heard any testimony that would support your client's motion to dismiss on number 7. Now, whether or not the monies go to whomever, that's a different story. Okay, you're saying that you didn't have room with heat, you have a room without heat and air conditioning, upstairs front room.
Again, I'm looking to call a witness, and
As it relates to the heat and air conditioning in the room?
yes, as it relates to everything,
No, I'm asking specifically about the heat and air conditioning.
also that, specifically that, yes. I've requested a continuance because I need to be able to, like I say, lay a foundation and call Ms. Collins. I'd like to call Mr. Branson. I'm trying to subpoena and call someone from the city.
Okay, so council, I've heard your request for a continuance, and I'm not likely to grant that right now, because this is now the 4th date that the parties have been back. This is the 3rd date that you've been here.
No,
Didn't you start on the 14th?
No.
Weren't you here on the 14th?
no.
Oh, no, you were not. This is the 2nd day you're here, I'm sorry. So which witness are you intending to call regarding the heat and air conditioning in the upstairs front bedroom?
I'm intending to call Mr. Branson and Ms. Collins.
Okay, well, then call them right now. They've been sworn in under oath.
Okay, but the problem is that I need time to deal with the exhibits. I still need a continuance, Your Honor. It's my 2nd time here. This is in less than a week. So I'm sorry that the plaintiff's procedural history is in whatever state it's in. However, again, whether, you've explained to me it's not a motion for summary disposition, but I can't emphasize enough that number 7 is just not true because it's not in compliance with local laws. That's what I was intending to discuss today. And of course, if, we need to pull the evidence to talk about that, that's fine. But the problem is I still need to be able to give my client a fair trial. And I don't feel I can do that under these circumstances. It would be different if I had been before you for a month, Your Honor. I would understand.
The compliance portion regards applicable state and local health and safety laws, okay? The ordinance that Mr. Branson may or may not be in compliance with based upon the certificate of compliance or certificate of occupancy is an ordinance, not necessarily something that falls under the health and safety laws. So the issues that we have to, so I think at this point, I'm going to dismiss the motion. I'm going to deny the motion to dismiss because the court doesn't find that the defendant was not being, or the plaintiff was not being truthful when he declared that the residential property was kept fit for the use intended has been kept in reasonable repair. Reasonable repair doesn't mean 100% in repair during the term of the lease or license and is in compliance with applicable state and local health and safety laws, okay? There hasn't been any condemnation notice put on the home. There hasn't been any other citations that Mr. Branson has received that would call into question the health and safety of the health and safety laws as relates to this property. Now, the other issues I indicated that I was going to address regarding the escrow, where the money goes, okay? Are you prepared for that?
No, I'm not. I was prepared to come here and discuss a motion to dismiss based on the fact that there's no certificate of compliance. You know, it's pretty straightforward in a lot of other circumstances.
What's pretty straightforward, Counsel?
Like if you're in a locality and they check that there's no certificate of compliance, then it's illegal to rent the property. So the complaint has to be dismissed if it's for non-payment of rent. It has to be treated like someone's squatting. You have to issue a 30-day notice to quit. You have to proceed like this. You can't proceed, and she's paid, so there's
Where's the law that supports that?
Okay.
Where's the law that supports that if Mr. Branson does not have a certificate of occupancy or certificate of compliance, that the tenant then has to be treated as a squatter?
That's not what I mean, Your Honor. What I mean is she's been sued for non-payment of rent. She's all paid up in rent. But if there is an issue where there's not a certificate of compliance, you hold a different opinion, but I've stated over and over again that 7 cannot be complied with. That's why a lot of cities are putting into their ordinances specifically that these an eviction cannot be, a judgment of eviction cannot be issued against a defendant in these cases because of that.
But MCL 125.530 indicates an action can be maintained. So if the state law and the local ordinance are in conflict, which one prevails?
It's silent in the local ordinance, but it does say you cannot rent without a certificate of compliance. It's still an illegal occupancy.
So then that is an issue that Mr. Branson will have to deal with the city of Wyandotte if they choose to issue anything regarding him renting property without a certificate of compliance.
Right.
So how does that fall under violation of a health and safety law?
Okay. I'm a little pulled in 2 different directions. 1 second.
Your Honor, while may I respond to her arguments, Your Honor, if it would?
Just for a moment.
Thank you.
I guess I need clarification. Is it the court's contention that ordinances cannot be health and safety laws?
I didn't say that they could not be health and safety laws. What I'm asking is what is the authority that states that the ordinance, right, and not complying with the ordinance is a violation of the health and safety law? That is what I asked.
There's not an assumption when there's a law written to protect health and safety that that's what it's for.
You're telling me that a certificate of compliance is to protect health and safety?
Absolutely.
Okay, where's the connection for that?
Because a certificate of compliance, a city goes in and does an inspection. A certificate of compliance in this case in particular, because obviously you can have commercial ones, is for residential use. That's to make sure that the tenant is safe and it's up to city code. That is the point. It is absolutely to protect the health and safety. It's absolutely pertinent. It's a health and safety law.
Where is the law that states that the ordinances of a locality that addresses rental properties falls under the health and safety laws of the state of Michigan?
I would like a 5-minute recess to locate a case.
Okay.
Thank you.
We'll have a recess. We'll go off the record. Okay, let's go back on the record in the matter of Branson versus Collins. 2402269, an appearance for the plaintiff again, please.
Good morning, or good afternoon, Your Honor. Amy DeCoray on behalf of the plaintiff, Mr. Branson.
Okay, thank you.
I'll leave that likewise, Your Honor.
Okay, Mr. Branson.
William Branson, Your Honor.
Thank you, Counsel.
Good afternoon. This is Megan Duckle on behalf of the defendant, Heather Collins.
Okay, thank you. Okay, and just so you know, there is an individual sitting in the court. She had scheduled a meeting to meet with me on some mental health something or other, I think, as part of her research class. She's on a mock trial team in the 33rd District Court, so she's not here at any point regarding anything with this case. I just wanted to state that on the record, okay? All right, so counsel, I did give you an opportunity to, wanted to look up some case law.
Thank you for that. I clearly need to brush up on what I learned in law school. It's the Home Rule City Act. So under the Home Rule City Act, and that's the State of Michigan Act, section 117.3 under mandatory charter provisions.
I'm sorry, it's MCL 117.3?
No, that's the section. Let me look up what the Home Rule City Act citation actually is. Okay. So it is MCL. No, that is correct. It's 117.3. And under that act, if you go under 117.3 and go down to section J, it states the public peace and health and for the safety of persons and property. In providing for the public peace, health, and safety, a city may expend funds or enter into contracts with a private organization, the federal or state government, a county, village, or township, or another city for services considered necessary by the legislative body. Public peace, health, and safety services may include the operation of child guidance and community, okay, it kind of goes on, it's contextual. The purpose of this act, Your Honor, is to state that the body corporate, which would be the city in this case, they are allowed to enact laws in the form of ordinances that protect the public peace, health, safety, and welfare, and carry out the enforcement of that. Now, in terms of a case, I can give you the federal side, or would you like the Michigan citation? Does it matter?
Well, hold on a moment. So before we get to the case, which the case is going to indicate how the laws apply, you're relying on MCL 117.3 to be the prevailing statute as to show that the not having the proper rental certificate is a violation of the health and safety laws.
Correct. This is an enabling statute. So it's a specific directive by the state of Michigan that what the city is doing is it's enacting laws that are for the purpose of health, safety, and welfare of its citizens, and they're responsible for enforcing those laws as well.
Okay, so under J, which is what you referenced, the public peace and health and for the safety of persons and property, in providing, well, actually, it talks about each city charter shall provide for all of the following. And J is the public peace and health and for the safety of persons and property. Is it, what's your phone doing?
They were on for the text messages.
No, there's only one that should be on, not they. Only one should be on, because only one is what we've been using for
I
text
text
messages.
messaged my boss to let her know I'm still not coming in yet.
Okay,
I had to work today.
you turned it off?
Yeah, I just turned it on.
Subsection.
So, hold on, Counsel. The public peace and health and for the safety of persons and property, providing for the public peace, health, and safety. A city may expend funds or enter into contracts with a private organization, federal or state government, county, village, or township, or another city for services considered necessary by the legislative body. Public peace, health, and safety services may include the operation of child guidance and community mental health clinics, the prevention, counseling, and treatment of developmental disabilities, the prevention of drug abuse, and the counseling and treatment of drug abusers. I'm not seeing anything in here how certifying rental homes falls under health and safety.
Absolutely, Your Honor. There's actually several mentions of health and safety and welfare within this statute. That is merely the first. One moment, please. But the case is certainly informative.
Your Honor, may I make a statutory construction argument?
Just one moment.
Thank you.
Okay. If you go down to section 117.35, it does reference the health and safety of persons living adjacent to land that's been condemned.
Okay, hold on. 0.35.
Yes. And then I'd like to direct the court's attention to the case.
Okay, what's the name of the case? Well, I'm trying to get to point 3.5, what's the name of the case?
It's called Sabab versus City of Dearborn.
Okay, SABBAGH, AUGH?
Yep,
Okay, is this a published opinion?
it is.
Okay, what's the citation, please?
384, Mish, 510, 1971.
Before I get to the case, I'm going to give Attorney Amy an opportunity to respond to the statutory portion.
Thank you, Your Honor. While I don't disagree with Sister Counsel that this is an enabling statute, this statute was intended by the state of Michigan to allow for the division of large parcels of land to become cities, states, or cities, townships, counties, and things like that. And it is a provision that allows them to enact statutes or to act ordinances and codes, and then thereby enforce their codes in manners that include, spending money to do it, and also to engage in contracts. But you're absolutely right on point when you pointed out to Sister Counsel that nothing in this statute indicates that this specific ordinance was enacted by this municipality, a quasi-legislative body, because a municipal ordinance is enacted by a quasi-legislative body, quasi-legislative body was intended to be for the general welfare. So this statute says, yes, cities can do these things. They have the ability to organize themselves and to create a government and to run their government and to collect and expend funds for the running of their government. But nothing in this statute is relatively on point to determine whether or not the CFO statute or ordinance is from is part of a health and safety or health and welfare was enacted for health and welfare purposes. And moreover, what you said earlier is actually right on point. When you question Sister Counsel about the interplay between the powers that be here, the state ordinance, which we know is, which we've cited many, many times as 125.530, and the city ordinance. When there's an interplay between a state ordinance that's directly on point in something, the municipality is not at will. And when Sister Counsel talks about this case, it's actually proven in this case that the city is not at will to abrogate that statute. The statute set forth the remedy. The statute did not set a private right in the defendant or in a tenant in this case. So while this statute said, yes, the municipality can do that, nothing in this statute says that that's what this municipality did, or that specific ordinance, the CFO ordinance, falls within the scope of health and safety of this community, Your Honor.
Okay, so just one moment.
Your Honor, I'm sorry if you're sick of hearing it, but I'm not sure how much longer we have to go. I again need to request a continuance. I wasn't anticipating being on the 5th hour, after it was scheduled. That's all. That's the reason. And I have other important business matters that I'm missing.
Okay, Counsel, when we scheduled this date, nobody said anything about having any time limitations, or else I would have addressed that at that time.
I didn't think it was reasonable that this would be this long.
So are you stating that it's unreasonable that it's going this long?
Frankly, with the situation in terms of the clear violation where cities are responsible for the public safety, health, and welfare, and that involves having proper licensure to collect rent under a lease agreement in a residential property, yes, I think that it should again be dismissed on that basis.
Okay, Counsel, you're making many leaps without having any connections to get you to the other side. Because even under the Michigan Occupational Safety and Health Act 154 of 1974, which is in the chapter 408 chapters, I have yet to see anything that would tell this court that a rental certificate falls under the Safety and Health Act, whether it's Occupational Safety and Health Act, whether it's any health act, anything, any of the chapters within the statutes. I have not seen that connection. I understand your thought process that because a house may not have a rental certificate, that there in and of itself is enough to say that there's a violation of health and safety laws. There's not a connection for that, to show that. The issue regarding whether or not Mr. Branson had a valid rental certificate is an issue that he's going to have to address with the city of Wyandotte if they so choose to pursue that. As it relates to your client and her obligation to pay rent without having a valid certificate of rental, your client isn't even allowed to withhold rent without depositing it into an escrow account. So clearly there is a lot of consideration for these types of situations because there's an entire statute on it in MCL 125.530. And nothing in here indicates that this would rise to the level of violating health and safety law, okay? Clearly, municipalities want to make sure that there are any homes that are being rented or anything of that nature, any buildings being rented for multiple purposes, right? They want to make sure that businesses are properly registered. They want to make sure that rental homes are properly registered. They want to make sure they know who owns what property. They want to make sure that if somebody is renting something, that things are up to code or what have you, okay? So that doesn't necessarily mean that falls under health and safety law, because I haven't even seen anything in the statutes, because these rental certificates, I believe, are good for 5 years. So within those 5 years, there's not re-inspections to make sure that the homes are still habitable and still complying with health and safety laws. So I don't find that not having a certificate of rental, a rental certificate falls under the health and safety laws. So you can respectfully disagree with me, and you've stated that you disagree with me, you don't find that it's reasonable, and that's your prerogative, counsel. If you feel as though I've gotten it wrong, you can certainly file an appeal. But this court does not find that there is a basis to dismiss this action on pursuant to paragraph 7. Because paragraph 7 states that the home has to be kept that has been kept fit for the use intended, which there hasn't been any testimony that's been not kept for use intended, which was a rental property, which is why the allegation that he doesn't have a rental certificate has been at the forefront, has been kept in reasonable repair during the term of the lease. Okay, I've heard some mention regarding an outlet, possible mold, but there's not anything that was put forth prior to this matter having already occurred. And it says reasonable repair, doesn't say 100% compliant without any repairs needed. And the court, and it also says it is in compliance with the applicable state and local health and safety laws. So this court's interpretation of that provision is the home has not been condemned. There have not been repeated citations issued to Mr. Branson regarding the violation of any of the codes or property maintenance or anything of that nature. So for those reasons, I find that the home is in compliance with the applicable state and local health and safety laws as far as that goes. Mr. Branson will have to deal with the city of Wyandotte if they so choose to proceed. However, if they do, with not having a rental certificate while he was renting the property and collecting rent. The court will also note that Mr. Branson, there's a check that was written at the beginning of November for an inspection. So we're talking, he moved in the month of June, about a little over 5 months of not having a rental certificate, not having a pending one or whatever prior to requesting an inspection. Now, I don't know what's happened with any of those communications. I'm not sure about any of that. But what was was submitted in an exhibit that I reviewed last night was that there was an email and a receipt, or not, I think, there was a receipt. And I think that there's also a letter included in one of these exhibits regarding that request. So I'm denying the motion to dismiss. I'm not denying your client or yourself, counsel, a fair opportunity to present evidence. I do not find a connection with the ordinance requiring a rental certificate to fall under state and local health and safety laws. So that's the ruling of the court regarding the dismissal. Motion to dismiss. So that's denied. I don't believe that there's any specific testimony that would alter this court's ruling as it relates to the motion to dismiss, because in this court's opinion, it's a legal analysis as to whether or not the property is in compliance with applicable state and local health and safety laws. But I went through the exhibits that were put forth and the issues that your client raised in her written motion regarding the flooding and the bugs, because that could potentially rise to that level. But based upon the testimony that I heard and the review of the messages that I reviewed, that does not seem to be the case. It appears as though Mr. Branson, when something was brought to his attention, treated it as it needed to be treated, or responded as it needed to be responded to. Now, as it relates to the issue of the June rent, let me do this. We have the June rent. We also have the security deposit, because I believe that your client, which I didn't specify this previously, I didn't make a note of it, but I recall that your client, that there was discussion regarding the security deposit, which I think, as we all know, that you can't do anything with that until after Ms. Collins moves out to determine what. I'm sorry, what?
I'm gonna stay till the end of my lease.
No, that is not what this court ordered.
This is, if you're gonna say that this is habitable and I've been paying my rent the entire time.
First of all, you just interrupted the court as I'm talking. But as I was saying, the court, as we all know, we cannot make a determination regarding the security deposit until after Ms. Collins relocates to see if there's any deductions or what have you. Now, Ms. Collins, you stated yourself that you were moving out. You did not want to stay there.
No.
You did. You stated that on February 7th or 14th.
No. You took my words and you twisted it, Your Honor.
I did,
Yes,
right?
yes, you did.
Okay, so what is it you said, ma'am?
I have, Your Honor, this right now is the only place I can stay.
No. what
Right
is it?
now, I just
No,
found out my
That's
cancer is
not what you
back.
said. No, that's not what you said. What is it you
I
said?
am 100% paid up to rent. This is an eviction. If I did not pay my rent, I was gonna have to leave. I'm
Ma'am.
staying until my lease is up.
Ma'am,
I
What is
appeal
it?
this.
excuse me,
I'm appealing this.
what is it that you said?
Then I'm gonna stay here.
No.
Yes, I did. I said that day that if you're gonna make me, if you're gonna make me pay, I was going to stay. That's exactly what I said that day.
I asked you if you.
That's exactly what I said.
I asked you if you wanted to keep living there, and you said, no, you don't. You said, I will gladly move out.
No, I did not.
Yes, you did,
No, I
because
did
then
not.
we got onto the discussion as to the escrow money and who gets the escrow money. Because you said, then I need my money back so I can go find a place to live. That is how that conversation went. So, the other issue that we have to address is the escrow money. Any other issues that we need to address?
Not at this time for a plaintiff, Your Honor.
Are there any other issues that we need to address, counsel?
No.
Just those issues?
Yes.
the June rent, oh no, the utilities, we have utilities that we have to address.
Your Honor, is there any way we could resume at another time with the rest
Yes,
of this?
I'm
Oh,
going to pick
okay,
another date, I
okay.
just wanna make sure we're all on the same
I'm
page.
just trying to get somewhere, okay, yes, the utilities. Utilities.
Okay, anything else?
I don't think so.
I need a timely manner to figure things out.
Yeah, I'm not telling you have to leave tomorrow.
Thank you.
I'm not saying that at all. Because I also recall that you say that you've been looking for places to move. So to tell me that I took your words and twisted them, ma'am, is not accurate,
You did.
okay?
Your Honor, I
So-
think you also requested that she provide to you the names and addresses
I
and
did.
phone numbers of the people that was contacted.
I will not get that to the court.
I did request that, ma'am, because you stated that you needed a certain amount of money to move out. So I was trying to facilitate some sort of resolution between the parties. That is why I asked you for a list of where and the cost that it would take for you to move there.
I'm looking at the cost right now is roughly between $4,000 to $5,000 to
Okay,
move.
that's why I asked you for something in writing
Yes.
to present to the court. Because
I do.
I have some credibility concerns based upon what's been presented to me and only wanting to give me partial information.
It cost me $5,000 to move here into this
Yeah.
place.
So I did ask for you to submit that information to the court as well.
I will have that next time in front of you, Your Honor. I thought it was unsafe because on YouTube I've been harassed.
What?
With your YouTube, I have been getting emails, I've been getting text messages because you put all my information out there.
I don't put your information out there, ma'am. Okay, so we live stream, right? Courts are live
I
streaming.
did not know that at that time.
Ma'am, it's posted all over, the sign's there, there's a sign out in the lobby, there's a sign on our website. There's plenty of notice that we live stream. We do not, and then we take it down after each of the,
And I would
after each of
have
the
never
days.
put my email to you, I would have never given you my email, I would have asked you to do that in private. I would
I
have
don't
never given
remember-
it to you.
I don't remember giving me your
You
email.
had me give it to you, and you also had me give you my place of employment, and I would have never given you either of those. I would have never given you those on.
Okay, I don't recall having you provide your email address.
Yes, you did.
Zoom. Not in the hearing, but, okay, and I apologize if I did, I don't recall that.
And getting harassed many times at work.
At work,
Work and so, and in my email, yes,
okay,
because of that.
okay, well, ma'am, I am unsure how to rectify that issue. I mean, I would hope that people wouldn't be contacting you, it's not appropriate, in my opinion. So, we're going to have everybody return, we're gonna pick a date. These are the issues that we are going to address. Everybody, I'm expecting to be prepared. I'm also expecting that there is going to be productive communication, conversation, exchange of information, whole information between counsel.
Hello.
And Ms. Dekwala, I did, and Ms. Counsel Amy and Mr. Dagger, I did review all of the communications that the court was CC'd on regarding the request for utilities, the refusal to speak to Ms. Kennedy, or respond to Ms. Kennedy because it's unauthorized practice of law. Counsel, she is a paralegal, apparently under the supervision of the attorneys, so there can be communication with that. So Ms. Kennedy, I apologize that we messed up your vacation day today and we haven't needed the body cam video. I don't know if we'll need it next time. I guess just have it ready to go in the event that we have to talk about it. I don't know. But the court is, let's pick the date.
Your Honor,
Yes,
I was attempting to discuss the utilities issue with Ms. Kennedy outside as per your directive last time,
okay.
and she would not go talk to Mr. Ali Dagger about what I was saying. That's why I said I needed to speak with him. She would not go and communicate what I was speaking
I'm
with.
talking about the email that went.
Right,
email
right,
communication.
but it's just a little bit harassing to me, honestly. That's the problem.
Your Honor, the real issue is that there was an email sent out where we asked Ms. Declala for information. It was that email. Ms. Kennedy followed up and said, hey, we needed these things from you. Ms. Declala responded to that email with abject vitriol towards Ms. Kennedy, telling her that she was, like, go get your boss. Like, you're not practiced to law. And then I responded. And I
Right,
said,
I reviewed all of those,
yeah, and
yes.
I need this information. And she told me, go get Ali. Like,
I didn't know who you were.
I had a notice of appearance on file, ma'am.
Okay, well, I hadn't seen it.
You were emailed it by men.
Please stop.
You were emailed by.
I am exhibiting respect.
Okay, she's indicated
I
that
just
she
want it to
sent you.
stop. I just want to focus, I'm sorry. I just want to focus on the issues in the case.
Okay, but I will also say, if there's this much emotion between counsel, it's going to be hard to focus on the facts of the case and the resolution of the case.
Judge, the bottom line is that we just need what she promised, and that is the evidence to support whatever allegation of overpayment of utilities. It's that simple. And we've been trying since the last time we were in court to obtain that information without any success. I would like the court to designate a specific time where that information can be exchanged. We have provided all of our documentation relating to utilities, but we haven't received anything that would evidence any type of offset.
Okay,
Could we set a time?
so, counsel, is there anything in the information that you and your client have regarding the utilities? Because I believe your client indicated she's overpaid utilities and she is entitled to a credit.
Why can we not engage in discovery requests between us?
It's a summary proceedings,
You
you know?
know, well, I don't know that I don't know that discovery rules specifically apply, but the court's ordering the parties to exchange information as it relates to utilities. So if your client's indicating that she's overpaid, you can turn your phone off now, ma'am. We don't need any more text messages, so you can turn your phone off.
Looking for dates, so we're gonna go to court.
Okay. Okay, so your client has receipts of payments, or what is it that she has that she's indicating supports her claim for overpayment of utilities?
So she has been paying via Zelle,
Okay,
an overall rental amount, I suppose. Because her landlord, the plaintiff here, texts her and tells her how much utilities she has to pay every month.
okay, so here's what I need. Here's what I need, I'm gonna spell it right out. I need from both parties text message communications regarding every utility bill that has been communicated, okay? That's the first thing I need. Then I need, if all the payments are via Zelle, I need proof from your bank, the bank statements that show the Zelle. You can even print up the Zelle, whatever it is, as to where it goes. Show the deduction out of your bank. Mr. Branson will show that it was deposited into his bank, okay? So, anything else that we would need, statements, we need the utility statements, that'd be Mr. Branson would have that.
They've been provided with those, Your Honor.
I'm not saying they haven't been, I'm saying what I need to make a determination on the utilities. Okay, so that is what I need as it relates to utilities. Okay,
Thank you, Judge. When do you want us to come back here? I know, we're all excited to be back.
March 14th. March 14th at 10 a.m.
Thank you for that.
Yeah, the escrow will continue, Your Honor?
Yes, March 14th at 10 a.m. Does everybody,
Yes.
That's fine.
Thank you for giving me that time.
Which day is that on, Your Honor? So that
it's a
doesn't-
Friday.
Your Honor, I work on Fridays.
Ma'am, I can appreciate that, but we have to get this matter resolved. I'm trying to give enough time so that there can be the information, excuse me. I'm trying to give enough time for the information to be retrieved and exchanged.
Yes, Your Honor.
And enough time, if there's any witnesses that need to be subpoenaed, to be subpoenaed.
Yes, Your Honor.
Thank you so much.
Thank you.
So, I would plan to be here for a number of hours,
Okay.
okay?
Yes.
I don't know how many hours that is, Plan to be here for a number of hours,
Thank you, Your Honor.
okay?
Thank you.
All right, thank you.
Take care.
Thank you. Oh, I'm sorry, hold on. The court did receive another order for inspection. And, counsel, I'm going to have you both look at it quickly, just so you can see what it is that the court's signing and that the provision regarding the third-party interference and automatic show causes, that was removed.
Between 9 and 2. Inspectors of the city of Wyandotte. Full cooperation of defendant.
Who else is gonna be there?
Just the inspector.
Nobody else, just the inspector.
Yeah.
And me.
Yes.
Mr. Branson will not be there.
That doesn't state
Well,
that.
I don't know if Mr. Branson is required. I don't know.
I will be there.
I would presume Mr. Branson would have to be there because he's the owner of the home.
Yes, ma'am.
And we did go over this last
I
time.
don't want police in my house.
Excuse me, we did go over this last time regarding whether or not,
Right.
Mr. Branson was able to be there, or if you had to be there. And the determination after reviewing the statute is that you don't have to be there, but Mr. Branson has to be there. You obviously have the right to be there, but I'm stating that Mr. Branson
Right.
would have to be there, he's the owner of the property.
I will not allow police on my property though this time, after what happened last time. I'm putting that on the record.
I don't know what happened last time, I don't know what happened last time, I haven't.
Oh, you should see the video.
They asked for my escrow account. They said that I'm in landlord tenant court and they didn't believe what was going on. It was a
I'm
joke.
sorry, but we have another hearing. I really have to go.
Counsel, I understand, hold on a minute. Miss Collins, just a moment. Counsel, I understand that, but I also am trying to prevent what I can foresee happening on Tuesday, Wednesday. What day did we say, the 26th?
That's 26, yeah.
That's Wednesday.
I would like for, if necessary, for the police to be there.
No,
I think to
I
maintain
would
the.
too,
No.
please.
I was
Hold on.
pushed aside and told I could not go into any room.
Absolutely not.
I have it on my security cameras as well. I was pushed aside and told I couldn't go into any rooms because I was in landlord tenant court. I had to show them my escrow papers or they weren't gonna believe me.
Absolutely not.
Okay,
Not anything
okay.
you asked for to happen.
What?
Not anything that you asked for to happen. I said, no, he's supposed to take pictures that I want to. They said, this is a
No,
joke.
no. I did not state, Counsel, you don't have to point at me.
No, I'm sorry, I apologize.
You don't, I did not say only the pictures that you want. That is not what I said.
No, I know that.
What I said was that Mr. Branson was to take pictures of the areas that you were stating were of concern. That didn't prohibit him, that didn't prohibit him from taking photos of other areas of concern that he had, okay? And that was specifically brought up on the record.
He wouldn't do that. He wouldn't take any pictures I asked him to. And they said they weren't gonna make him.
Ma'am,
It was a joke, and I don't want police in my house.
ma'am, let me just say this, okay? I cannot predict the future. I cannot predict behavior. What I will say is if a city inspector feels the need to contact the police because there may be a disturbance or there may be some concern
I
or
will be
other,
very nice, but they're not.
excuse me, please stop interrupting me and we're not done.
Heather.
We're not done. Please come back up here. I cannot tell the city inspector that they cannot call the police. Okay? I cannot tell them that. So what I'm saying is,
He's gonna call them, they won't.
ma'am, Mr. Branson, here's what I'm going to say. There's not a need for civil standby during the inspection. There's going to be an independent person there, the inspector. And I expect everybody to be on their most adult, appropriate behavior for the entirety of the inspection. That means not communicating in the ear of the inspector as to what they need to look at or anything of that nature, okay? The inspector knows what their job is that they have when they arrive at the home. There should not be any videotaping. There should not be any video recording. There should not be any audio recording. There should not be any communication at all, other than, hi, how you doing? Welcome to my home, whatever, something simple like that. That is it.
I promise you that, Your Honor, except for my security cameras, correct? Our security cameras out of it.
I don't know what your security cameras, would they go on when people walk in, I don't know what that is.
Okay.
I don't know what that is.
I promise I'll be exactly civil this time, 100%.
If the city inspector feels the need to contact the police for whatever reason, that is their right. That is their prerogative, okay? That is what I'm saying. I'm not prohibiting a third party who's not under the jurisdiction of this court from contacting the police.
Thank you.
Thank you.
Thank you so much.
Thank you. Have a good weekend. We'll see you back on the 14th at 10 a.m.
Sounds good.
Do you hear what she just said?
Wait, hold on.
Hey,
Hold
hey.
on. Hold on. Please come back.
Hold on. Please come back.
Oh,
Mr. Gander, what is it you just stated to my court officer?
I just stated, Your Honor, as she was leaving, she called
Who's
me,
she?
Miss Collins called me a name, asshole.
I did not. I swear I did not. 100% I did not.
Well, ma'am, you flipped him off last week.
Okay, so you're gonna believe everything he
No.
has to say?
Ma'am, I said you flipped him off last week.
Okay, and I admitted to it, did I not?
You admitted to it.
Yes,
Okay.
and I am not admitting to this. And I admitted to things I said in the hall. I'm not gonna admit to something I didn't do. I admit to things I do.
Okay, so I'm gonna have Ms. Collins and Ms. DeQuala for you to please leave.
Thank
Not
you.
saying anything,